Kowalski for the people.
Judge, good morning to you and the staff. Vincent Haysha, appearing with and on behalf of Mr. McConan, who's present via Zoom.
Sir, can you state your name?
Aaron McConan.
All right. What are we doing?
Judge, if I could, last time we were in, I was awaiting videos from the Washtenaw County Prosecutor's Office. I received those Tuesday. I also received what would be a global offer on all the matters that are currently in circuit court. However, although it would be my advice for Mr. McConan to waive his exam at this time and proceed to circuit, I went to the jail yesterday, did not have an opportunity to see him because they had a several-hour backup. So I don't know if the court would put me in a breakout. I know that's not customarily allowed.
That's not going to happen.
I know, Judge. I figured I'd do an end around. I don't at this time. I haven't spoken to him about acknowledging the waiver for today. And so we could either set for exam or the court could give us a probable cause next week. I don't know that we're going to go to exam. I would strongly suspect we're not going to.
Probable cause will be adjourned. What's next week?
Next week is the 21st.
September 21st, 2023, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Court calls the case of the people versus John Hernandez.
Nimesh Ganatra for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Hernandez.
All right, what are we doing?
Your Honor, we've reached a resolution on this matter by which my client would be pleading to use of a controlled substance. There is a sentence agreement to 7411. And the defense would be asking the court to release Mr. Hernandez today.
There's a sentencing agreement between counsel, although it's my case, I'm not agreeing to 7411 until I see a evaluation, so that you know. So I don't know if that changes your posture on it or not.
Do you understand what the court just said, Mr. Hernandez?
No, what was that?
I'm not agreeing to 7411. I don't do those sentence agreements. I'm not saying that you won't get it, but I don't agree to it. And I'm not going to agree to it until such time as I see an evaluation.
On a first offense, okay.
So, Mr. Hernandez, if you can either enter the plea today or we can adjourn it a week and I'll come to the jail and we can discuss your options.
I mean, I'd rather not sit here another week. Like I said, my mother is sick and I need to help her.
Mr. Hernandez,
That's
what do you want to do?
that's fine. I mean, is it being used then, right? A misdemeanor use,
Yes,
and I will be released today?
that's up to Judge Simpson. I can't guarantee that.
Okay. Let's go with it.
We're prepared to proceed. Thank you, Judge.
Thank you, Mr. Overwater. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record.
John Hernandez.
Sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance, that being fentanyl. That is a misdemeanor, punishable by up to 1 year incarceration and or a $2,000 fine plus court cost. Do you understand that?
Yes, I do.
Understanding that, you still wish to plead guilty.
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Not at this moment. I'm on bond, I believe.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
I'm sorry.
And also because you believe that you're guilty of this offense?
Yes.
On May 4th, 2022, at the location of 5495 West Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, did you have fentanyl in your possession?
Yes,
Had you used it?
yes,
And did you know what you were using was fentanyl?
no,
Okay, what did you have in your possession that you thought you were using?
Elazapram, Xanax.
Counsel, what do you want to do on this?
Mr. Hernandez, did you have a prescription for that?
Yeah,
A
you.
valid prescription?
Not a valid one, it's outdated.
Okay, so you were possessing a controlled substance without a valid prescription?
Yes,
Judge, I would still be
Thank-
satisfied with that factual basis.
all right. Thank you, Mr. Overwater. Are the people satisfied?
We are, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and screening and assessment is ordered at 14A1. Sentencing in this matter will be October 11th, 2023, 9 a.m. before me. As the bond, is there an
Yeah.
issue?
This, my client has, this is my client's first drug offense. He has, I believe, one misdemeanor conviction in his criminal history for an attempt resisting. He did have a warrant issue for some positive tests. He turned himself in on that warrant. My client developed an opiate addiction, which was caused by being prescribed opiates for a host of medical problems that he's had to endure. As a result of those medical problems, he's on disability, but prior to being put on disability, he had been employed for 30 years. He resides with his mother in Tecumseh, Michigan. He cares for her. We'd be asking the court to release him today on a personal recognizance bond. Before he was taken into custody, he was going to Ann Arbor Comprehensive Treatment Facility on a daily basis. He's in the methadone program there, as well as group therapy and individual therapy. So he is taking the necessary steps to treat and try to manage his addiction. He has taken responsibility for possession. In this case, it is a misdemeanor offense. I would ask the court to release him on a personal recognizance bond today.
Response from the people?
Mr. Overwater's representations about the criminal history seems to be accurate. That's the information I have. The only thing I would share with the court is that you're aware of the prior community corrections engagement. And I think that that gives at least a good background of what led up to all of this in terms of the plea. The people trust your judgment on any release if that happens and what terms and conditions would be in place. So we'll leave it in your discretion. Thank you.
Thank you. What I will do is he can be released after his on a PR $25,000 personal recognizance after he has his PSI appointment. I am going to also order community corrections intensive day reporting for this defendant. So we'll step that up a notch and see if he can comply with that one without violating. If not, he'll go right back in. Understand that, sir?
yes,
All right, thank you.
Thank you, Your
Court
Honor.
calls the case, People versus Ryan Carter Price.
And on behalf of the people,
And good morning, Your Honor. May it please this honorable court, Matthew Rosenthal on behalf of Ryan Carter Price.
Mr. Price, Carter Price, can you state your name, please?
Yes, Ryan Carter Price.
Thank you. All right, what are we doing?
Yes, Your Honor. Good morning to you and your staff. We were retained on the case yesterday. I don't have any discovery. I would like to adjourn this out a week or two, whenever I can get discovery from the prosecutor's office. I will be sending that over. But we were going to address bond conditions, Your Honor. Right now he's at $75,000. We were wondering if that could be reduced and if he could be put on a tether, if that would be an option at this time. Something more feasible. He does work at a noodles company in Ann Arbor, and he has been incarcerated for the last 8 days since Wednesday, Your Honor.
Response from the people.
Your Honor, at this time, we would ask that bond be remain the same. I believe he was currently on a circuit court probation for another DV third. And in this case, they were the victim and him were arguing. She was holding their son and he pushed her over while she was holding the son, was shaking her, tried to grab her glasses off her face and he also scratched her. She tried to leave. He ran up behind her, began to assault her again by pushing and pulling her, pushed her down 2 more times. And when officers arrived, they saw that she had scratches on her arm, face, and the area around her neck. Her sweatshirt was also ripped. And he has numerous previous dismissed DV cases, as well as a 2015 DV, 2017 DV, 2021 assault intent to great bodily harm and a misdemeanor DV that was dismissed, a 2022 assault, and then a 2023 DV third. So we would ask that bond be kept the same.
Any response to that?
I mean, he won't be around the alleged victim, Your Honor. He'd be on a tether at his mother's home. We don't want him to lose his job and further debilitate him from being able to take care of himself or child. Mhm.
Yeah, okay, but is there a probation violation that's pending in circuit court on a DV or any other court? I mean, is he on probation on a DV?
I had in my notes that he was on circuit court probation for a DV third with their guidelines of 5 to 23 on September 7th. That was entered into the notes.
September 7th. So he's currently before on a DV third, and I now have this case, or this case is before me. September 6th. Okay, I see what the deal is here, I think.
Absolutely, Your Honor.
Probable cause will be adjourned September 28th, 2023, 9 a.m. Motion for bond reduction or change in bond is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Case of the people versus Sekou Kande. 2 cases.
Nimish Ganatra, First Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Odetella on behalf of Mr. Kand.
All right. And what are we doing on these 2 matters?
Under counsel and I have been talking about the discovery. We're waiting for cell phone extraction to be conducted by law enforcement. So if you would agree to an adjournment, we would appreciate that.
I don't have a problem. How much time do you think you'll need, given the nature of the cases?
I'd recommend 4 to 6 weeks, Your Honor.
Weeks. Give me 6 weeks out.
So October 26th.
Probable cause will be adjourned without objection October 26, 2023, 9 a.m. Or as your Zoom invite indicates, bond will continue in 1 case as denied. All right,
Thank you, Your
thank
Honor.
you.